Alrighty, folks, you are welcome to get started. You are live. You can begin.
Hi, good afternoon, everybody, and welcome to this afternoon's webinar. My name is Alexander Rufus Isaacs. I'm the president-elect of the Beverly Hills Bar Association, and I'm also a member of the board of the Beverly Hills Bar Foundation, which is the association's 501c3. This is quite exciting. It's the first in a series of webinars we're planning entitled The Foundation Presents. And we'll be focusing on legal topics that will hopefully be of interest to non-lawyers because they affect all of us as well as lawyers. We will be exploring issues such as the rule of law and freedom of speech, for which the Beverly Hills Bar Association has been a strong advocate throughout our 92-year history. The foundation provides scholarships to deserving candidates to our local law schools. And here's a short video from one of our recent scholarship recipients. No volume.
You have to check those two boxes before you share the screen. Otherwise, people can't hear sound.
Can we run it again with the sound on, please? Sorry about this.
My name is Luis Vasquez, and I received a Beverly Hills Bar Foundation Public Interest Scholarship while a student at UCLA Law. As someone who is first generation, gay, Latinx, and pursued a non-traditional path, that support has been essential to my success in this field. Indeed, after graduation, I remained at UCLA as an LGBTQ legal scholar, and am now a senior attorney with the Human Rights Campaign, where I'm working to oppose discriminatory laws nationwide. I encourage you to donate to support other students who are pursuing careers like mine. The BHBF has been awarding scholarships to students at 5 LA region law schools for 50 years, and they need your help to meet their goal for this year.
That's great. Indeed, we do support, the foundation supports many charitable causes. This webinar is being provided free of charge. We do ask you to consider making a voluntary tax deductible contribution to the foundation by clicking on the link that's in the chat box. And also, please put July 26 in your calendars, which is the date for the next webinar in this series, which should appeal to anybody who's interested in the environment, the subject being the incredible success of a coalition that won approval to remove 4 huge dams from the Klamath River in Northern California and Oregon. So please attend on July 26 to find out why this is such an important development for all of us. Now, on to today's webinar, which has its genesis in an article in The Guardian back in February, the title of which was Atlanta Shooting, Part of Alarming US Crackdown on Environmental Defenders, subtitle being 20 states have enacted laws restricting rights to peaceful protest as environmentalists are increasingly criminalized. And this immediately struck Ken Petroulis and I as an interesting topic, and we reached out to Steve Rohde, who was very enthusiastic and who is moderating today's webinar. Steve was president of the Beverly Hills Bar Association in 2004 through 2005, and is rightly regarded as one of our great leaders. He's a true constitutional scholar. He's a lecturer, a writer, a political activist, and was a prominent civil rights lawyer before he retired. He's founder and chair of the Interfaith Communities United for Justice and Peace. He's past president of the ACLU of Southern California, past chair of Bend the Arc, which is a Jewish Partnership for Justice, and he's on the board of Death Penalty Focus. He's the author of 2 books, America's Words of Freedom, The Words That Define Our Nation, and Freedom of Assembly, and he's co-author of Foundations of Freedom, A Living History of Our Bill of Rights. He's written for the Los Angeles Times, Huffington Post, Truth Out, American Prospect, Truth Dig, and Ms. Magazine, and is a regular contributor to the Los Angeles Review of Books and to Los Angeles Lawyer Magazine. His article in the Daily Journal on today's topic is included in your materials. He's a graduate of Northwestern University and Columbia Law School. Before I hand over to Steve to introduce the panelists, I want to thank particularly Ken Petroulis, who would have been introducing this program today had he not been on vacation and completely off the grid, lucky man. He is a longtime foundation board member and former president of the Beverly Hills Bar as well. And he's the one who's taken the lead of putting this webinar together. Thanks to our wonderful staff, especially Belinda, Genna, and Leslie. You should have already received the materials for today's webinar, and your MCLE certificate will be emailed to you later. Please post your questions in Q&A. We will get to as many of them as possible at the end. And lastly, my apologies that despite our strong protestations, the English Premier League went ahead and scheduled Chelsea versus Man United for exactly this time. So we have a conflict and may have lost a few folks, but everybody else, I hope you enjoy yourself. And with that, I'm going to hand over to Steve.
Thank you so much, Alexander, who we know as Zan. It's such a pleasure to be with all of you who are attending this webinar today. I'm genuinely grateful to the Beverly Hills Bar Foundation, the charitable nonprofit wing of the Beverly Hills Bar Association. I'm grateful to Ken Petroulis and to Alexander, to staff people like Leslie Aguera and Jenna Kolnikov. This Bar Association is dedicated to the rule of law, to the advancement of civil rights and constitutional rights. The Beverly Hills Bar was founded in 1931 by a group of Jewish lawyers who were excluded from the Los Angeles County Bar Association. And they formed this organization, which for those 90 years has done extraordinary work. And I'm so proud to have been associated with this group. And now to have this inaugural rule of law webinar made available free to all of these participants, as well as being recorded so that you and others can watch it in the future. I want to be sure you know of the Q&A function where you can put in questions, which we will try to leave some time for toward the end. And also, please take advantage of the materials that all of us have accumulated that supplement and will add so much additional information and background knowledge for every one of you as a participant in this program. The topic today couldn't be more relevant, more pressing, and because of the kinds of legislation we're dealing with, couldn't be more dangerous to the rule of law and to a vibrant democracy, which depends on First Amendment rights of expression and of peaceable assembly and the right to petition the government for redress of grievances. After all, America was literally created as an act of protest. Protest has been the backbone of American history, and the history of America is a tribute to the power of protest, seeking further justice and equality. One of the glories of democracy, Dr. Martin Luther King Jr. wrote, is the right to protest for right. And our history, while full of some failures, largely successes, the major accomplishments in American history have been accompanied by the exercise of the right to protest. Ensuring women's right to vote, earlier ending slavery, protecting the rights of working people to organize, dismantling white supremacy, protecting the right to dissent during war, and periods of political repression, reducing the risk of nuclear annihilation, preserving the environment, protecting the rights of persons with disabilities, guaranteeing marriage equality, protecting reproductive justice, and the struggle to safeguard the dignity of every individual. You cannot think of American history without thinking of the right to protest. Unfortunately, as has been true in dark periods in American history, this right of protest is under serious and widespread assault. Since January of 2017, 45 states have considered over 267 bills to restrict the right to protest, according to the International Center for Not-for-Profit Law. Recently, at least 40 new laws have been enacted, and many more are pending, which would restrict the right to protest, including laws that limit where people can protest, laws that provide immunity for motorists who harm protesters, laws that enact penalties for protests near oil and gas pipelines and other critical infrastructure, laws seeking to have organizers who plan demonstrations held financially responsible for the cost of protests, and laws that provide overly broad definitions of a riot or other key terms. In 1939, the US Supreme Court in Hague versus CIO held that wherever the title to streets and parks may rest, they have immemorially been held in trust for the use of the public, and time out of mind have been used for purposes of assembly, communicating thoughts between citizens, and discussing public questions. The last decade alone, we've seen Americans joining in massive, unprecedented protests expressing outrage over racial injustice, police violence, and women's rights. But these repressive anti-protest laws that are proliferating, we have to ask, will the American people, elected officials, and courts reject attempts to suffocate what Dr. King called one of the greatest glories of democracy? To explore these issues in great detail today, I am so proud that we have assembled an extraordinary panel of individuals that you'll be hearing from very shortly. Sabine von Mering is a professor at Brandeis University. She holds a PhD in German studies from UC Davis and has been at Brandeis since 1998, where she has co-authored the past 3 climate action plans. And she teaches a course on human nature, human/nature, European perspectives on climate change. She's just written a book, Beginning to End the Climate Crisis, A History of Our Future, published by Brandeis University Press. And she's currently co-editing a handbook on grassroots climate activism. Sabine has been a climate activist for many years, which she will tell you about, and she has been arrested 3 times for her climate protests. And as we will see, these are an example of the escalation in the punishment for protests. We're also joined today by Jeff Filipovich. Jeff is a civil rights lawyer practicing in Atlanta, Georgia. He has represented organizations including the Georgia Mental Health Consumer Network and Prison Legal News. He has spoken at seminars. In 2011, he received the Georgia Mental Health Consumer Network Humanitarian of the Year Award. And in 2013, he served as chairperson for the Mental Health Committee for the Georgia Association of Criminal Defense Lawyers, who named him as Appellate Lawyer of the Year. He's a member of the National Lawyers Guild, the National Police Accountability Project, and the Georgia Association of Criminal Defense Lawyers. Excuse me. Our third panelist is Brian House. He is senior staff attorney with the ACLU's Speech, Privacy, and Technology Project, where he focuses on free expression issues. Since joining the ACLU in 2012, he has litigated cases defending the First Amendment rights of writers, journalists, media organizations, activists, advocacy groups, labor unions, and private citizens. His lawsuits challenging state restrictions on political boycotts of Israel are featured in the documentary film Boycott. He regularly discusses First Amendment issues in the media and at law schools. He was a 2021-22 Wasserstein Public Interest Fellow at Harvard Law School. He is a magna cum laude graduate of Yale University and Harvard Law School and served as law clerk to the Honorable Marcia S. Brazan of the U.S. Court of Appeals for the Ninth Circuit. As you can see, we have some of the best people available to discuss these issues. Our format today, I will be turning to Sabine to give us a grounding in her firsthand experience with protesting and what motivates her and the consequences of her actions. We'll turn to Jeff, who has represented over 100 protesters in Georgia, including the events of Occupy Atlanta, Cop City, and the escalation of law enforcement and the chilling effect on activists. And then we'll be joined by Brian, who will use the McKesson versus Doe case as a precursor of this new wave. He'll talk about NAACP versus Claiborne, a key U.S. Supreme Court case, and he'll discuss the attacks on boycotts being a clear form of political expression. We'll have some conversation among the panelists and myself, and then we'll look for your questions in the Q&A box in this seminar, and we hope to wrap up within close to an hour. I really am eager to turn the program over to Sabine von Mering.
Thank you very much, Stephen, and welcome everyone. I just wanted to begin by correcting something. I translated the book that you mentioned. It was actually written by two young German climate activists. But thank you very much for having me. It's really fitting that you invited me, given that Brandeis is not only named after the first Jewish Supreme Court justice, but also celebrates its 75th anniversary this year as the first secular university founded by the Jewish community. But obviously I'm speaking today not on behalf of the university, since I'm talking about civil disobedience. I'm going to start by explaining why I engage in civil disobedience as a climate activist when I could certainly be doing other things. It's actually quite simple. So first of all, as soon as one is aware of the fact that what humans are doing to the climate, that the fact that it poses unprecedented threats to life on Earth, and we're all seeing that, whether you look at the floods in Italy or wildfires in Canada, or the combination of droughts and flooding in Somalia and elsewhere. The UN Secretary General Guterres calls it a climate time bomb. So as long as political leaders are not treating this as the emergency that it is, I agree with Henry David Thoreau, who wrote in his pamphlet on the duty of civil disobedience, I say, break the law, let your life be a counter-friction to stop the machine. What I have to do is to see at any rate that I do not lend myself to the wrong, which I condemn. He then goes on to say, under a government which imprisons unjustly in this case, it was about abolition, of course, the true place for adjustment is also a prison. And further, if the alternative is to keep all just men in prison or give up war and slavery, the state will not hesitate which to choose. Secondly, the consequences of climate chaos that we're already experiencing disproportionately impact those who contribute the least to the problem. So it's the social justice issue par excellence. And finally, a journalist once asked me after an action, "Professor, why do you go to such lengths and risk arrest when you could just sign petitions or organize a vigil instead?" And my reply was, well, I've been doing these things you mentioned, like I went to the big climate march in New York in 2014, for example, but this is the first time that you called. Right, and that is also what Dr. Martin Luther King Jr. wrote in his letter from Birmingham jail. Quote, "Nonviolent direct action seeks to create such a crisis and fosters such a tension that a community which has constantly refused to negotiate is forced to confront the issue. It seeks so to dramatize the issue that it can no longer be ignored." So that's the why. Now, let me use these 3 points as a lens to talk a bit more about the arrest that led to my facing a felony theft charge, to be precise, in June of 2021. I had been charged several times before, twice with misdemeanor charges for protesting, and then, went through the system as expected. And in this case, it was also initially a misdemeanor charge, and then the courts decided to up the charge to felony theft. Now, Enbridge, the Canadian pipeline company that built the Line 3 tar sands pipeline, had before and has since been repeatedly fined or had to settle due to environmental violations. So it is a good opponent to have, a good enemy to have, and it's an example of the wealthy corporations kind of doing the real criminal acts. Tar sands is the worst in terms of its carbon footprint, and so Line 3 equals a carbon bomb, just like the Keystone XL pipeline did, which we protested against for years before President Biden finally put an end to it, which also goes to show that protests really matter. And the indigenous communities whose land is being violated by the Line 3 pipeline, and who also had fought this pipeline for many years through petitions and testifying, etc., are, of course, among those who have contributed the least to the problem and who are suffering the most under the consequences. In fact, studies show that indigenous groups around the world have disproportionately been protecting our biodiversity. So you could argue they are part of the planet's defense system. And so I felt strongly that as an older white lady professor with European background, it was my responsibility to show up in support of the local water protectors. And I can tell you the love and care for the earth and the people and the deep understanding of our connectedness across generations that ground the indigenous folks to the land and the waterways was deeply inspiring as I was up there in northern Minnesota. For many, participating in civil disobedience is, of course, a luxury. It requires time commitment as well as other resources, and it's important that those of us do it who are able to engage in it, especially those who are older and who have benefited the most from the fossil fuel age. So since I'm speaking to a bunch of lawyers here, I want to emphasize that when climate activists engage in civil disobedience, we do so as a team. We're in this together from the moment we connect to the very end of the legal process. And I want to give a shout out to Marla Markham and others from the Civil Disobedience Center who helped us tremendously with navigating the post-arrest legal territory, because we really try to work together as defendants, and lawyers don't always understand this, namely that protesters are willing, for example, to risk a higher fine or a higher penalty to remain in solidarity with each other. The criminalization is not just an injustice perpetrated against protesters, and this includes protesters who try to reveal the horrendous torture of animals inside factory farms, for example. But before I go to this, I just want to mention, like, this to me felt like I'm stopping a weapon of mass destruction, right? This is the drill that was being used under the water to drill for the pipeline. Anyway, so the protesters that are being, criminalized, the criminalization is an attempt to silence those of us who reveal wrongdoing on the part of large corporations and sometimes the government. And that's why these tendencies are particularly dangerous in a country where money has so much influence in politics, because it basically protects the real criminals from being held responsible. You can absolutely imagine that future generations will put fossil fuel and similar corporations on trial for the destruction from which they have so handsomely profited. The courts are another place where this fight is already being fought. The German equivalent of the Supreme Court actually ruled in 2021 that the German government had to update its climate law in response to a protest and then a lawsuit, because it was failing to protect future generations. That was a historic decision. And there's a similar lawsuit in the US, Juliana versus US, where young people are demanding that the government protect their future.
Sabine, we're eager to get to your arrest and then move on.
Okay, well, I talked about the arrest. So I think I just wanted to also mention that the protesters that this is not an issue that's only happening in the United States, but also in Germany. Yesterday, there was a big raid against protesters who were involved in civil disobedience there. So we are being criminalized, not just in the United States. And I just want people to know about this book and film, because that is really what is the biggest part of the problem. So that's it.
Well, just briefly, you were arrested for what otherwise could have been a misdemeanor. And
Yes.
Then those charges were escalated to a felony. Just briefly describe that.
Yes, I was arrested for a misdemeanor. And then I was told in court that they were going to change the charge to felony theft, with the argument being I had tried to steal the truck, as if I could have gone anywhere, since I was locked on top of it. So there was no way for me to go anywhere, right? But that was the charge that I was, and it was an abuse of the law, but as we found, as we looked into it, the law was also written in a way and changed in a way, is my assumption, so that it could be used in this way, so that people could be charged with theft for simply denying someone the right to use their property for temporarily.
Thank you so much. Thank you for what you're doing. Thank you for being here, and we'll get back to you and have more conversation about your activism. Let's turn to Jeff to give us a sense of what it's like in Georgia, what he is facing in his legal representation of protesters there. Go right ahead, Jeff.
Sure. Good afternoon. My name is Jeff Lipovitz. Just to give you all a quick background on the perspective I'm coming to this problem from. Our law firm handles civil rights claims, mostly 42 USC 1983. We handle excessive force a great deal, police shootings, malicious prosecution, and medical neglect cases. Over the years, though, especially as I was coming up, being a 2009 graduate into a world of unemployment, I handled a lot of protest cases for many years. If there was a protest, I would do it. So that started with Occupy Atlanta, and that has continued on. Now that's waned because the need to make money has increased as the size of my firm has increased. So the protest cases have waned somewhat. How we got involved in this is we were retained by the family of Manuel Paez Terán, who was the activist who was shot and killed in the publicly owned forest, staging a sit-in protest here in Atlanta. And that protest centered around something called Cop City. I want to give you all a quick overview of the circumstances around that, while simultaneously pointing out to the government overreach that's happening, with the ultimate lesson being here is we don't need new laws to overextend here. We have plenty on the books already. And it's really a matter of who is checking the government, because they have plenty of statutes as it is. So in case you don't know, Cop City refers to the city of Atlanta's police training center, which is going to be the largest training center for police in the country. It is being constructed in DeKalb County. It's not part of the city of Atlanta, it's just land owned by it. And it's in a forested area just outside of the city, one of the very few undeveloped areas. And it's been very controversial. There's been a lot of opposition to it from the start, but the city council has been in lockstep. We have a lot of corporate donors and a lot of money coming into the project. So the protests have started, with sit-in protests, sitting in the forest, sitting in trees, camping out, and the like. They have escalated, and I'll show you a video shortly about what that escalation has looked like. Where over the years in Atlanta, there have been problems with how they've handled protests, but we're talking about things like they arrested someone for being a pedestrian in the roadway because they stepped off the sidewalk for a second, and they're just picking people off at a protest. Typical stuff, typical overreach, led to some lawsuits. We've litigated some of those. Many of our friends have litigated those, but nothing that I considered to be out of the ordinary, nothing that made me say we need to have a press conference and sound the alarm bells about this until now. So I'm going to, prior to the death of Manuel, and I'm not going to go into details about that now just because it'll take up too much time, but prior to Manuel, who was shot and killed by officers in the forest, there had been no claimed act of violence by these protesters. The throwing rocks, maybe setting a piece of construction equipment on fire was the extent of it. And so I'm going to share my screen now because I want you all to see, I'm going to show you the law that is being used here and show you the factual basis for it. So this is a quick map just to get everyone oriented. This area here is Cop City. That's where the new training center will be. This is a movie studio that's coming out to, you all are exporting everything from California into Atlanta, it seems. And right in here is this ICP, that's Entrenchment Creek Park. That's the publicly owned land where much of the sit-in protests were being staged, including Manuel Terán. So what did we see happen? Here's the statute we're dealing with, domestic terrorism. So you all can read it. I'm not going to read it to you. But we read the statute. It seems like it would apply to things like shooting up a power plant, taking out a substation, disrupting a water supply, and the like. Let me show you how it's being applied here. This is an arrest warrant charging someone with criminal trespass. Seems right? That's how we do protests. That's how we do civil disobedience. You break the law, you take the consequence because the message is more important than your well-being as far as that criminal charge goes. So that's fine. I have no problem with that. That's how it always goes. Here's one. What's the charge? Domestic terrorism. What's the factual basis for it? Fleeing from the police, causing injuries to the officer's right knee and right elbow. Said injuries being scrapes and cuts. What? How does that make sense? It doesn't. And as someone, malicious prosecution cases are some of my favorite cases. And this one makes me think, oh, I love that. I love this case because that factual basis in the warrant is what the officer is stuck with. But it's not like we have a one-off thing here. Here's another one. So we're going to talk about this top part momentarily. The accused affirmed their cooperation with the defend the Atlanta forest by occupying a treehouse on site, refusing to leave, and posting videos and calls for actions on social media sites used by DTAF. That used to be called a sit-in protest. Now it is called domestic terrorism. Another example, sleeping in a hammock with another defendant said accuses also a known members of a prison abolitionist movement. Dear God, this person's political beliefs are so important to the charges, they actually made it into the warrant, setting forth the factual basis for it. Unbelievable. Here's another one. Occupying a treehouse, refusing to climb down, resulting in over a 12-hour standoff. Also present on the property during the shooting of a state trooper by an activist, which resulted in serious injury and the subsequent shooting of said activist, that being Manuel Paez-Terán. So there was a question in the chat. Do you consider January 6th a protest or a riot? Easy, both. How do you feel about valid civil protest that ends up in property damage being property damage? I feel like the new rule is if you're part of that protest, you're a terrorist. And that's the march toward authoritarianism that we have happening here in Atlanta. So that domestic terrorism law isn't brand new. It wasn't designed to be, anti-protest piece of legislation. It was passed in the wake of the shooting in Charleston. And so in my 45 seconds we have left, what we have here is this, the January 6th question is appropriate because what do all the people on the left say, right? Do we want Donald Trump prosecuted for that, right? Danger. That's how we get the march toward authoritarianism. We have, and here in Atlanta, we have an even more dangerous situation because we have not only the two parties pointing at each other, you saying upping the ante, we have the alignment of the parties against these environmental protesters. We have the mayor of the city of Atlanta, hand in hand with Governor Brian Kemp. Obviously, the mayor here is a Democrat. I don't know if you all, I assume Brian Kemp might be a national name at this point, but if not, standard Republican governor. Hand in hand, these cases are being prosecuted by the state attorney general's office. What do those guys get if they do a good job? What do they get? Judgeships, right? Of course, they get appointments from the governor's office. And so that's what's happening here. A lot of these guys were denied bond, guys in the general sense. A lot of these protesters were denied bond. Most have been released now, but spent months in jail for this. And I have a video clip, but I'm running out of time. So I wanted to show you all how this has escalated, because one thing that has happened is after the death of Manuel Terán, obviously there's been a lot more agitation. And the protest tactics escalated to match, well, I won't say to match, but they've escalated. And, that's often not a good combination, because as soon as, and who knows who's planning it, because let's not pretend that these groups are not infiltrated. If they're not, then it's incompetent police work. But the escalation that's happened has kind of played right into the hand of the authoritarianism that we see here. And so that's a brief glimpse about what's happening in Atlanta. It's a frightening situation. There have been collateral consequences. We've had reports of people's bank accounts being frozen who are associated with this group, even if they haven't been arrested. And the situation is unfolding, and I don't know where it will go now. So I'll leave it there for now.
Thank you very much, Jeff, for the hands-on sense of what's going on in Georgia. And we'll get back to some of these questions contrasting January 6th with other protests that we're talking about. But let's turn to Brian to give us really an overview of these laws and some of our constitutional precedents. Brian?
Thanks so much, Steve. It's a pleasure to be here speaking with you all. I'm just going to share my screen here for this presentation. All right. So when we talk about the right to protest, I think many people conceive of it as a right of free speech. But as Steve was mentioning earlier, it's also really a right of assembly. And that often gets kind of lost in the dialogue over protest rights. So I think I'd like to start there and where the right of assembly really comes from in the American constitutional tradition. So you probably, many of you remember from your 7th grade civics textbooks that, in the run-up to the Revolutionary War in the 1760s and 1770s, the American colonials were very upset with parliamentary policies, particularly regarding taxation. And so they implemented a series of colony-wide boycotts of British goods to express their opposition to parliamentary policies. These boycotts were implemented through town meetings, which were regularly held in colonial cities and villages throughout the country. So when Parliament really got fed up with these acts of protest, what they did is they passed the Massachusetts Government Act of 1774, which made it illegal for colonists to gather without the prior approval of the governor. And the idea was that by preventing the people from assembling, they could prevent them from engaging in mass political demonstrations that were disruptive to Parliament. In response to this, the First Continental Congress, not a governmental body, but simply the organizing arm of the revolution, essentially, declared the right of the people peaceably to assemble, in direct contradiction of what Parliament was trying to tell them. And those are, of course, the words that ended up in the First Amendment. And so since then, the First Amendment has not just protected the right to speak, it's also fundamentally protected the right to gather with other people, especially in public places, for the purpose of making your voices collectively heard. And so here's a sample quote from a Supreme Court decision from 1981. The practice of persons sharing common views, banding together to achieve a common end is deeply embedded in the American political process. So whether you're talking about collecting names for a petition, organizing a protest march, or organizing a boycott, the idea is that when Americans get together to collectively express their political beliefs, the government should not be interfering with that. Today, I want to talk about 3 different ways in which this right of assembly is under attack. The first way is attempts to impose, and I think you've already heard about this from Jeff and Sabine, attempts to impose associational or conspiracy liability on anyone who organizes or participates in a protest that involves some illegal activity, right? So protests are large, can sometimes be unruly things. There are a lot of different people participating in them. It's always going to be the case that one or more of those people might engage in some sort of illegal activity. And then the question is, who can be held liable for that? What you see in these authoritarian attempts that Jeff was mentioning is government attempts to expand the scope of that liability to cover anybody who participates or organizes the protest. So for example, I think in those arrest warrants Jeff was showing, they said that they were present at this protest when an officer was shot, implying that their mere presence at the protest was enough to make them liable for everything that happens by any other person at the protest. A second way in which we see attacks on protests are attempts to outlaw specific types of protest activity, and that's when I'll talk about attempts to suppress boycotts on the grounds that they're not expressive. And finally, there are attempts to basically just outlaw being in certain public places, or to use laws in ways that they're not intended to be used to basically expand the scope so that if you step onto the street for even a second, they say you're obstructing traffic. And it basically makes it impossible for people to gather in a public place. So turning first to the attempts to impose associational liability, as Steve was mentioning, McKesson versus Doe is a case at the cutting edge of this issue. The case concerns, and just in the interest of full disclosure, we represent Dre McKesson in this case. Dre McKesson's a Black Lives Matter organizer. He participated in a protest in Baton Rouge, I believe in 2016. The complaint in the case alleges that at some point during that, Dre directed some of the protesters onto the public street, that's an infraction under Louisiana law, a traffic infraction. That as a result of that, the sheriff's office was called in, or the police department was called in. There was a standoff between the police department and the protesters, and one of the protesters, don't know who, picked up a brick and hurled it at the police officer. The police officer suffered very serious injuries. But he didn't sue the protester who threw the brick. He sued the hashtag Black Lives Matter I'll just say candidly that I don't think his lawyer is that good. He sued the hashtag Black Lives Matter, the Black Lives Matter organization, and DeRay McKesson. The district court dismissed all of the claims, but on appeal, the Fifth Circuit revived the claim against DeRay. And it essentially said that he had, in allegedly directing the protest to violate the Louisiana traffic ordinance, he'd violated a duty under public law, and then he was liable for any harm that was foreseeable as a result of that violation. So according to the Fifth Circuit, allegedly, the mere act of putting protesters onto the street meant that he could foresee there would be a police standoff, and he could foresee that someone would throw a bic, and he's on the hook for all of that. The implication of that rule would essentially mean that protest organizers are always exposed to massive damages liability anytime the protest violates even the most minor time, place, or manner restriction or a traffic ordinance. It would make it basically impossible, I think, to organize large demonstrations without the risk of massive financial liability for anything that might happen. This was a contentious case in the Fifth Circuit. I think the panel ended up releasing 3 decisions. Judge Willett ultimately dissented, issued a strong dissent from the panel decision. It had a deadlocked en banc vote in the Fifth Circuit, so the panel decision was upheld without opinion. The Supreme Court subsequently took the case and vacated it. And we argued to the Supreme Court essentially that this case stands in direct contradiction to a very important Supreme Court precedent on the right to protest, NAACP versus Claiborne Hardware. Claiborne Hardware concerned a group boycott of white-owned businesses in Port Gibson, Mississippi to protest racial segregation and inequality, and it was organized by the NAACP, and particularly an NAACP activist named Charles Evers. The stores did not like being subject to this boycott, and so they sued all of the boycott participants for all of the damages resulting from the boycott, including Charles Evers. Now, the Mississippi Supreme Court ultimately held that the boycott campaign was an illegal conspiracy. Because some people who participated in the boycott campaign used violence or intimidation to enforce compliance with the boycott. But instead of just holding those individuals liable, the Mississippi Supreme Court said, anybody who participated in the boycott is liable because now the whole boycott is the conspiracy. And then specifically, Charles Evers is liable. And the Supreme Court rejected that 9-0, or actually I think it was 8-0 because Justice Marshall was recused. And they said that the power of the states to regulate economic activity could not justify the complete suppression of a nonviolent, politically motivated boycott to affect political and social change. And they said that Charles Evers could not be held liable for the conduct of the boycott participants unless there was evidence that he directed, authorized, or ratified the unlawful conduct. And the very important principle there is that you are responsible for your own unlawful actions. You are not responsible for the unlawful actions of people who are simply participating in a First Amendment protected protest together with you. And so we said in DeRay's case, there's no allegation that he directed, authorized, or ratified someone throwing a brick at a police officer. On that ground, this decision can't stand. Whatever Louisiana tort law says about it, it's inconsistent with the First Amendment. I think the Supreme Court took a minimalist approach to this. They basically said, we want to understand if Louisiana tort law even covers this issue. So they sent it back down to the Fifth Circuit and ordered the Fifth Circuit to certify questions of tort law to the Louisiana Supreme Court. Unfortunately, I believe late last year, the Louisiana Supreme Court held that DeRay's conduct does constitute negligence under Louisiana tort law. So now the question is back to the Fifth Circuit. Does the First Amendment prohibit that application of tort liability in DeRay's case? And that's what we're waiting to hear from the Fifth Circuit now. Just wanted to briefly touch on another case that I think also addresses these issues. Dream Defenders versus DeSantis. And actually, I think this is the one that Steve wrote on recently in the LA Law Journal. So this is a case where Governor DeSantis redefined the meaning of riot under Florida law to mean willfully participating, whatever that means, in a public disturbance, whatever that means, involving an assembly of more than 3 people with shared intent to engage in disorderly or violent conduct. We, together with the NAACP, sued challenging this law, and the district court enjoined it, and basically saying, you know, this law is extremely vague. Nobody knows what willfully participate means, for example. And read broadly, it could criminalize merely recording a protest in which illegal activity takes place, and that would obviously violate the First Amendment. The 11th Circuit, like the Supreme Court in McKesson versus Doe, took a minimalist approach and said, before we even get to these issues, we would like the Florida Supreme Court to weigh in and address whether the way this law defines willful participation in a riot, how broad the scope of that liability is, and then we can address the First Amendment question. So it's now on certification to the Florida Supreme Court. The second issue I'll just briefly touch on are attempts to outlaw boycotts as a form of protest. So more than 30 states have passed laws requiring government contractors to certify that they're not participating in boycotts of Israel or Israeli settlements in the West Bank. These laws have recently begun expanding to cover other types of boycott activity, including boycotts of firearms manufacturers, fossil fuel companies, businesses that refuse to provide reproductive or gender affirming care, and businesses that don't release diversity statistics or that have non-diverse management. We think these laws violate the First Amendment right to boycott, which the Supreme Court recognized in Claiborne Hardware. And so we've been suing in various states around the country, challenging these laws. We initially had a great deal of success. We won preliminary injunctions in Kansas, Arizona, Texas, and Georgia, basically holding that those laws violate the First Amendment right to boycott. Unfortunately, we had a loss in Arkansas Times. This is a case where we represent a newspaper that doesn't participate in a boycott of Israel, but doesn't want to be forced to sign a form giving up its First Amendment rights. The Eighth Circuit ultimately held in an en banc decision that the First Amendment does not protect the right to boycott because the Eighth Circuit said boycotts are not, the act of refusing to buy something, the Eighth Circuit said, is not by itself individually an expressive activity. You wouldn't know if someone is boycotting just by looking at them. You'd have to see what they say about it. And under a case called Rumsfeld versus Fair, the Supreme Court suggested that symbolic conduct, such as flag burning, is protected under the First Amendment only if it's inherently expressive, if a bystander would understand it as expressing a message. And so under that test, the Eighth Circuit said boycotts are not protected. But I think that's fundamentally a category error because the Eighth Circuit was treating boycotts as a form of individual expression, when in fact they're an exercise of the right to assembly. And when you're dealing with assembly rights, you can't look at the itemized, atomized individual actions and say whether those particular things done by a single person, whether or not they're expressive. You have to look at the whole group, right? So if you talk about a parade marching down the street, if you just talk about the act of walking, well, the act of walking is not inherently expressive. But of course, that's not what we think about when we think about parades. We think about hundreds or thousands of people marching together, singing songs, chanting slogans, carrying banners. All of that is part of the parade activity. All of that is protected as a First Amendment form of expression. And if the government could just say, oh, well, we're not passing a law about parades, we're just passing a law that says you can't march down the street in front of the Capitol. It would make it very easy to outlaw all of that expression and fundamental violation of what I think the First Amendment is designed to protect. And on that point, I'll just lastly briefly address precisely attempts to outlaw protest in public places. Many of these laws or prosecutions are in the aftermath of George Floyd's murder. Of course, there was a long period of protest and distress in the country over those shocking incidents. And in response to that, we saw many states and cities start passing draconian laws designed to prevent any sort of public expression. So I think a classic example of that is an ACLU case, NAACP Alamance versus Peterman. And this is when the city of Graham initially passed a law making it illegal for two or more people to gather in public for the purpose of protesting without first getting permission from the chief of police 24 hours in advance. That law was so obviously unconstitutional that shortly after we filed the lawsuit, they changed it. I think they didn't want to go to court with that one. Instead, they passed a law making it illegal basically to engage in any sort of protest around the county courthouse, which is basically the major public building in that community. And so it would have effectively prevented most forms of public protest. And fortunately, the district court struck that down and said, this is inconsistent, as Steve was mentioning earlier, from Hague versus CIO. Streets and public places have been held open time immemorial for the purpose of Americans gathering to make their views known, and attempts to suppress that outside the courthouse, for example, flatly violate the First Amendment. The last case I want to briefly discuss is another ACLU case. It's a criminal appeal we're currently litigating in Texas. They're racial justice organizers in PRO Gainesville, again, engaged in a march just around the courthouse in Cook County, calling for the removal of a Confederate war statue. The protest was entirely peaceful. They just marched several times around the courthouse following a preset route. But at one point during the protest, several of the organizers allegedly stepped into the street. And so that meant that the county ended up prosecuting them for obstruction of traffic. There's no allegation that in any way they blocked cars, that traffic was impeded in any sort of way, that there was any sort of hazard to pedestrian safety or anything like that. It was simply the fact that because their foot touched the street at a certain point during that protest, that they had committed obstruction. Unfortunately, they were convicted, so that's why we're on appeal now. Our argument essentially is that the obstruction statute has historically been interpreted in Texas and must, in order to be consistent with the First Amendment, it must be interpreted to require actual obstruction of traffic. And a mere fleeting moments of stepping into the street can't be the basis for a criminal obstruction of traffic prosecution. So I think that covers the three main threats that I see today.
Thank you, Brian. Just packed with information. While I have you, because it's been asked, how would you distinguish some of the cases you've been discussing with today's 18-year sentence to an organizer for the Proud Boys for seditious conspiracy? What's good for the goose? Can we see why that case is valid versus the kinds of protests that you and the other panelists have been talking about?
So I want to caveat this with saying that I'm not deeply familiar with the charges in that prosecution. But my rough understanding is that the government alleges that the Proud Boy conspirators, planned to invade the Capitol and disrupt Congress from performing its duties. And so, a conspiracy to engage in an illegal act of that nature, fundamentally obstructing the administration of the government, is, I think, categorically different than desire simply to be present in a public space. Now, you can make, moral arguments for why they should be treated similarly, but I think legally, the law recognizes that when you intend an unlawful thing and you engage with other people to do that unlawful thing, you can be held liable for the consequences of those actions. With these other cases I'm talking about, the individuals who are being prosecuted or who are being sued, there's really no allegation that they intended to do the main unlawful thing, right? So in DeRay's case, for example, there was no indication that he directed, authorized, or ratified someone to throw a brick at a police officer. Instead, the Fifth Circuit saying, if you do any unlawful thing, you're on the hook for everything else that follows, regardless of whether you had any control, knowledge, or awareness of it. And so I think the fundamental line that Claiborne draws says we're responsible for our own actions, but in general, when you're engaged in a First Amendment protected activity with other people, you're not responsible for their actions. And so that's, I think, the fundamental distinction there.
So if I'm hearing you correctly, the test that eventually the Supreme Court will have before it in the Proud Boys case is whether the Department of Justice presented evidence of directing, authorizing, or ratifying unlawful conduct in the case of January 6th. And that's, of course, what the jury did find. And we will see further clarification of that. I think it may be very interesting to see whether that kind of a protest case comes before the Supreme Court before or after the kinds of cases that you are dealing with. And we're only going to have to wait to see. Because of your extensive presentations, which I found fascinating, and I hope our participants do, we are bumping up against our time. Zan, did you see any other questions in the Q&A function which are worth hearing from our panelists?
Stephen, yes, there is a very interesting question that's just been posed, which I think I'd like to read out. One moment. Here's the question. What do you make of apparent efforts to suppress protests that express politically disfavored viewpoints, e.g. protests against police violence, through non-legislative means? For example, police violence / mass arrests in the wake of George Floyd's death. There is a pending class action against the LAPD in the Central District of California for excessive force against many nonviolent protesters, whereas other protests in Southern California advocating more right-wing viewpoints have not been responded to with similar violence by the police. How do these conflict with or complement legislative efforts to suppress disfavored protests? Thank you, Benjamin Levine.
Let me turn back to Sabine. If you track that question, what is your experience in the political content of your protest influencing how the police reacted and how authorities react when it is disfavored political viewpoints of the kind that you're expressing in those situations?
Yeah, that's an interesting question. I mean, I was certainly aware of the many Trump signs in the area. And it does, it does, I mean, I'm the non-lawyer here in the room, and I have a hard time following the legalese, to be honest. But I think what Jeff was pointing to is really the important piece here, right? That we have to make sure that the law is followed in ways that it doesn't, that we don't, because we have an inherent need for justice, that we don't actually go overboard and by demanding restrictions on those we oppose and end up hurting ourselves. That said, I would say, as someone sort of naively, as a non-lawyer, intent should matter, not just because of, I mean, we're engaging in civil disobedience, we're risking arrest, but for what aim, right? What is the goal of the civil disobedience you're engaging in? And there, I think you see huge differences on the two sides. And that, I think, should also be taken into consideration. I don't know if it does legally or not, but I feel like if I'm doing this, Bill McKibben was saying this at an event in March. He's been arrested numerous times to try to protect the water and the air and the climate, right? Like, if you're doing something in the service of everyone, in support of everyone, that should be different from someone engaging in what I would call rioting, to restrict other people from expressing their rights, and to actually, to hurt other people's right to freedom of expression.
Thank you. Well, as we wrap up, given time constraints, and I think we could do another hour seminar on these issues, I want to turn to each panelist and ask, many people are watching this seminar today. It's not a passive activity to be a member of American society. So, Jeff, starting with you, in your community and in the cases you've handled and the clients you've represented, if people are outraged by these new prosecutions, these new laws, what can individuals do in their communities to address these new assaults on First Amendment rights?
I hate to sound like a cliche, but it's all government. So it's all elections. It's all about representatives. It's all about organizing. You don't need to be in the street. For whatever reason, that is not something that you could do because of your livelihood, your job, or anything else. But having relationships with your city council members, I mean, this is a local issue. Running for office, organizing people to vote. It's not the fun stuff, but it's, we have close elections here in Georgia now, very close. It could come down to hundreds of votes next time. And so, that kind of engagement is what we need more than anything. We don't need more people, attacking construction equipment right now. We've got other, not to say that's not valuable, I'm just speaking locally here. we've got a lot to do, and the more people who do that work, the better.
Brian, what are your thoughts on this issue of activism?
Well, I think Jeff's exactly right that, charity begins at home, and the first place to focus is your local government. So, writing your representative, participating in the elections, making them aware that you're upset over anti-protest legislation that's being passed, I think goes a long way. In addition to that, you can contribute to, for example, for bail funds that ensure that people who are arrested, for charges relating to protests, don't have to necessarily spend time in jail awaiting their prosecution. And serving as a protest monitor. Groups like the ACLU, for example, often have volunteers go to protests and just monitor what's going on, so that when officers start acting unlawfully, for example, using excessive force against protesters, there's civilian presence there to document that. You have a First Amendment right to record officers executing their duties in public places. And I encourage you to vigorously use that right, so long as you don't obstruct them from engaging in their activities. You'll be protected by the First Amendment. And that form of accountability both ensures that officers who misbehave are brought to justice, and it prevents and deters future attempts to use excessive force against protesters.
And Sabine, your final thoughts on what others can do in these times?
Yeah, I think the voting and getting politically engaged is always good. However, it's really important that we understand that the future generations, the youngest people that are going to hit hardest by the climate crisis, they are not going to be the majority for a long time. They are a small minority. Even if they all voted, they would not have majorities to get the kind of legislation they need to protect their future. So I think in addition to getting involved, it also really requires alliance building across generational and other differences. And that means old people have to stand up, white people have to stand up for Black people, old people stand up for young people, and straight people have to stand up for the LGBTQ communities. So that requires more than just voting.
Well, thank you. Thanks to all our panelists. I'm very grateful. I'm pleased this has been recorded. We did go over time, but I think it was justified. In closing, we are on the anniversary of the murder of George Floyd, and the district court in Florida, in the case that Brian discussed, the Dream Defenders versus DeSantis, said that those draconian laws were the Florida legislators' reaction to a summer of nationwide protests for racial justice against police violence and the murder of George Floyd and many other people of color, and in support of the powerful statement that Black Lives Matter. There's actions and reactions, and then there are further counteractions, and I think that's what this conversation today was meant to trigger. We hope it's thought-provoking. We hope you take this information back to your own communities, to dinner across the table, to your friends, to your workplaces. I'm very grateful to the Beverly Hills Bar Foundation for convening this program, and I wish you all a very safe and good afternoon.